Course resumed. Please be seated. I apologize for the late start, Justice Hennessy. We've had some tech problems, and in particular, my colleague, Ms. McNamara, who's sharing the screen, has not been able to access the internet in the normal way, so she's hotspotting off a phone, which means that it's possible it'll go down again. And we'll just keep going as best we can, but I apologize in advance if we need to take another break.
Well, I understood that there was something invisible to blame.
Okay, so where we left off, I'm at 2B of the outline that I provided this morning. We're talking about, actually we're at 2C, Canada's December 20th letter of offer. And I had gone through scenario 1 and scenario 2, both of which arrived at a figure of about 2.51 billion plus interest.
Mm-hmm.
And now we're looking at the third scenario. And again, we're at tab 46 of the record, which is where the December 20th letter of offer is. And scenario 3 was an alternative approach, a new approach. This was a new approach. It starts on page 60 of the letter, or page 3029 of the record. My colleagues brought it up there. Scenario 3, the alternative approach. This was something new, having in mind the nature and severity of the breach, which was one of the things we discussed during the engagement and negotiation processes. We heard from the First Nations on that issue. Canada, in this scenario, took Hutchings' full estimate of NCRR, brought forward at the band trust account rate. Not the bond rate, but the band trust account rate, updated to 2024. So you've seen, and I won't take you back to it unless you want to look at it again, at tab 55C, Mr. Schachter showed you Mr. Hutchings' analysis of the various figures when you apply different categories of whether you do, which rate you bring it forward at, and whether it's NCRR or NCRR plus. Would it help if I brought that up again?
I'm just going to put it in front of me.
Okay, it was tab 55C.
This is it, right?
Yeah, it's up on the screen now. And really, that's all. Okay, it's also Mr. Schachter's compendium, tab 13, but it's on the screen. Thank you for that. Thanks. So the figure that we took was the one that my colleague has highlighted there. It's 100% of NCRRs at the band trust account rate. We're looking at 11,032 million. Reading that right? 32 million. Yes.
That's at 100%. Right.
That's 100% of NCRRs as estimated by Mr. Hutchings. Now, Canada actually added to that. We added the 120 million that Canada determined to use to represent annuities or NCRRs going up to the end of 2024. And remember, I had advised you earlier that Canada felt, because the Supreme Court said in paragraph 304 of its decision that the Crown was to determine an amount to pay up to the present, Canada brought that amount forward. So the number that Canada used in scenario 3 was actually more than the 11,032 million. It was 11,152 million. And then in this case, Canada looked at, again, a range of 20 to 50% for the First Nations. And in scenario 3, maintained that a 20% share would be honorable in light of the relative population numbers and the needs of the Superior Anishinaabe. And Canada noted this is particularly so where NCRR are based on the plaintiff's full estimate brought forward at the band trust account rate. So in other scenarios, where Canada had gone up to 50% share for the First Nations, Canada said, in this kind of scenario, because Canada had said,
Because we took 100%, now we'll go to 50%.
no, because we're taking 100% of
We'll go-
Hutchings NCRR, the share for the First Nations, Canada does not feel 50%. It always has to be 50%. It's in the context. What is fair and reasonable as between 20 and 50%? And Canada determined that when you're talking about not $5.5 billion of shareable wealth, but $11,152 million of shareable wealth, it's reasonable to give the First Nations a lower end of that share between the 20 and 50%.
Doesn't it suggest, doesn't it suggest that the 50% or the 20% is not a principled position? It's really just based on the total dollar number. So if you go up to 100% of the NCRRs, then you take the share down. If you take a lower amount of NCRRs, then you take the share up. Wouldn't that be somewhere where the mind might go?
It might, but let me explain, Justice Hennessy.
Okay.
Canada has taken this position from the beginning, always taken the position that it's somewhere between 20 and 50%.
Yes.
And took the position at the stage 3 trial and in the stage 3 trial submissions that the exact percentage is going to be somewhat dependent on the total amount to be shared in order to arrive at an amount that is overall, when looked at holistically, a fair and reasonable amount overall.
Well, that's just what I thought the answer would be, because you're looking at it overall. You're looking at the global amount.
You're looking at a global amount. And when you actually take a look at the 3.6 billion that Canada ends up arriving at, that's, some 30 some percent or 20, I haven't figured out the math. At the moment, I forget, but the ultimate amount that Canada determined to pay, if you wanted to express it as a share of the NCRR, it is more than 20%. But the point is, Canada has legitimate fact-based reasons to be using a share of between 20 and 50%. We went through that briefly before. It's 20% was based on, and I'll get into it in more detail later when I address share, but it's based on the population at the time in 2023, at the time of the trial, was roughly 10% of the population was Anishinaabe in the Superior Territory. And Canada doubled that to 20 to take account of the fact that percentage doesn't necessarily reflect the needs. And at the higher end, 50%. But even 50% is based on, well, it has some.
Can you tell me what the population is? 10% of what?
Of the population of the Robinson Superior Territory. That in Northern Ontario. The Anishinaabe represent about 10% of that population in the present. Now, over time, over the last 100 years, the average has been, the Anishinaabe population has been on average about 6%. We'll get to that, but I mention it because you might have remembered reading that in Canada's letter and in its submissions. But in any event, the point I'm making is that whether it's a 20%, whether it's 50%, they both have bases in the evidence.
And sorry, remind me, the 50% is?
This is simply
theory.
because it's bargaining theory. And I would submit to you that that is just as amorphous a determination as the 20% based on population. It's just a reasonable way to look at it. And one of the things this brings my mind to was Mr. Schachter made the point, well, his clients look at it as the Crown should be paying NCRR plus 25% of the difference between NCRR and rents. Mm-hmm. Ontario says it should be NCRR plus an additional 25% of NCRR. And Mr. Schachter says, no matter how you slice it, you end up with roughly the same number. Mm-hmm. So overall, we're looking at a number that is holistically fair and reasonable and proportionate. And that's the same point that I'm making now. And again, the standard here is honorable. And the Supreme Court has told us there's a range of honorable results. And Canada's position is 20% is honorable. And One of the grounds Canada relies on is polycentric considerations, and we'll get into that when we address share specifically. But Canada's position is 20% is honorable, up to 50% is honorable, depending on the overall context. So that at the end of the day, the result is honorable. And in fact, I would say fits within a range of what is honorable. So when you take a look in scenario 3, Canada looked at, okay, let's take the total number of $11+ billion. If Canada were to pay the Anishinaabe an honorable 20% share, then the total compensation due under this scenario would be $1.928 billion. And that's at page 16 of the December letter, page 3030 of the record. Sorry, I said 16, I meant 61. So you'll see it's up on the screen for you now. Under scenario 3, where you take a 20% share of the 11+ billion, and you deduct the $302 million already paid in annuities, the total compensation due under this scenario would be roughly 1.928. But Canada didn't just settle on 1.928. It was sort of a validation check, if you would, or a benchmark. It was looking at it from different perspectives. How can you come up with a figure that is honorable overall? Canada said, well, if we look at the scenarios 1, 2, which is essentially Canada's stage 3 position updated to 2024, and with Canada paying 50% as a share with Ontario. See, that gets us at about 2.51 billion plus interest. This way of looking at it, scenario 3, which is 2% share of Hutchings' full amount of NCRR at BTA rates, is about 1.9. And that makes it look like the 2.5 is honorable. It's fair, reasonable. It derives out of a rational chain of analysis that uses a methodology that the First Nations themselves have supported, which is not the specific numbers, but the methodology, which is you take the Crown benefits, you take the present value of that, and you give a share to the First Nations. So this is this position of ultimately 2.5 billion, the range of 2.51 billion plus interest, is, as I said, it's fair and honorable because it is rationally connected to the facts and the law, and rationally explained. So in its December 20th offer, Canada didn't just stop at the 2.51 billion plus interest. Canada took those 3 scenarios, from the 1.9 to the 2.51, and considered what Canada heard at the negotiation and engagement sessions with the First Nations, what Canada heard about the impacts of the nature and severity of the breach. Canada also considered the less tangible aspects of the claim, such as psychological and emotional harms. And these are described in Canada's letter, the same letter at tab 46, at page 2,981 of the record, which is page 12 of the actual letter. Where Canada explained in this letter of offer, it explained the general principles. It talked about an assessment. The compensation is to be an assessment, not a mathematical calculation, which was a point we discussed repeatedly at the stage 3 trial. And Canada goes on to say, Well, I'd like to actually start that at the page before, the bottom of page 11, the beginning of that paragraph where it says Canada agrees with the First Nations that compensation to be supportable must be based on rational, fact-based elements and not on whimsy. This was something that the First Nations had indicated they expected in their letter. Canada agrees that significant weight should be given to the fact-based elements from the Stage 3 evidence, including expert calculations on net Crown resource-based revenues. At the same time, there are some aspects of Canada's decision-making to determine an honorable amount of compensation that require the exercise of judgment on less tangible concepts, such as, quote, social and policy considerations, close quote. That comes from paragraph 294 of the Supreme Court decision. And the First Nations, quote, emotional hardships, close quote, or, quote, emotional and psychological loss, close quote, among others. These are in quotations because they come from the First Nations letter saying, Canada, your decision, or Crown, your decision has to take into account emotional hardships, emotional and psychological loss. Canada recognizes the need for a reconciliatory justice response to Canada's breach of the treaty. Canada's determination of its offer of compensation takes into account social and policy considerations and hardships suffered by the First Nations that are not readily quantifiable. Canada's assessment of compensation in these circumstances, or even the fact-based elements, the quote fact-based elements, which is the evidence of the experts, economists, even that is not capable of mathematical precision. And that brings us back to what we discussed at the Stage 3 trial. And I'm going to get into again more about these numbers that the experts give us are different perspectives. They're not science. And, you know, they're estimates based on models. They're not mathematically precise. So just to continue on that sentence, it was Canada's assessment of compensation in these circumstances, where even the fact-based elements are not capable of mathematical precision, and many other elements for consideration are intangible and not readily quantifiable, has required rational, informed, holistic, and polycentric decision-making. And therefore, Canada concludes at page 3034 of the record, which is the same letter of December 20th. We're at page 65. That the proposed honorable compensation is a total of $3 billion. So Canada effectively moves up from the position it had taken at Stage 3, where we were at 2.45 billion, to now the position that it is offering on December the 20th of a total assessment of $3 billion. Which, just to recap, is based on.
Can I just ask one thing?
Yep.
When you say a total assessment, the 2.45 was also total, was it not?
Yes, it was. It wasn't just Canada, it was total.
Yes. Go ahead.
So, so then we've seen the evolution from it was 2.45 as the total amount of what would be honorable compensation was Canada's position at Stage 3. Now, after this process of engagement and negotiation, Canada has recognized the nature and severity of the breach, these polycentric considerations, intangible things like emotional loss, social and policy considerations, psychological loss, and Canada's come up with a global figure of $3 billion. Now, Canada goes on, and you see it in that letter following under page 65, 3034 of the record. Canada then discusses Ontario's role and says, Canada has determined the amount of compensation it is offering to the First Nations based on Canada's own assessment of the compensation owed, and with the purpose of addressing Canada's unique obligations to the First Nations under the treaty and flowing from the honor of the Crown. Canada expects that Ontario will conduct its own assessment of the amount of compensation that it owes to the First Nations in order to discharge its unique obligations to the First Nations.
Were you prepared, was Canada prepared to offer a different amount than Ontario? Was Canada prepared to go to the First Nations with two separate amounts from two crowns?
Well, that's addressed in the next paragraph. When Canada says this offer, but this isn't the exercise of discretion. This is the offer to settle, where Canada says this offer is conditional on Ontario either paying, matching or exceeding. So in that sense, the answer is Canada was not prepared to pay more than Ontario.
So I had read that before, so I'm sorry about the question, except when you read the paragraph, Canada expects Ontario will conduct its own assessment.
That is, Canada expects that Ontario's own assessment is going to come up with a figure that matches Canada's or exceeds it. But Canada's paying 1.5.
No matter what Ontario offers.
No matter what Ontario offers, because Canada has conducted.
Now I want to get to there. So Canada was prepared to go to the plaintiffs with a different number.
Than Ontario? Yes. Because Canada conducted its own assessment its way.
Okay, I just want, yes. And no matter what Ontario did, you would not increase your offer.
That's correct. And again, the language that Canada used was Ontario's offer, this offer is conditional on Ontario matching it or exceeding it.
So what does that mean?
Well, if Ontario.
What would you have done if Ontario had not matched or exceeded it?
That is not in the record. What would the Crown and Right of Canada, what would the government of Canada or the Minister of Crown Indigenous Relations decided to do if Ontario said, we're not going to pay? It's 1.5.
Mm-hmm.
We don't have evidence about what the minister would have done in that circumstance.
Well, what we know is that the plaintiffs who received that letter didn't know what you would do either.
No, they didn't. And in fact, this was a contentious point when the letter was delivered because the First Nation said, why is your offer conditional? It shouldn't be conditional. And in fact, of course, the later exercise of discretion was not conditional. Here, this is a settlement negotiation, and Canada is trying to bring Ontario to the table, saying, we've assessed it this way. We're prepared to pay 50% of our assessment. We're expecting Ontario to match that or exceed it. And as I said, this isn't an exercise of discretion, it's just an offer. It's a negotiation process here. Then I'd like to move to, so after this offer went out in December, and in fact, Ontario did come out with its own offer that fortunately matched Canada's on Ontario's own assessment of how and why it arrived at its figure. But fortunately,
what's the timing difference between Canada's offer and
the offers were delivered on the same day, which is December the 20th. Canada's explanation letter was delivered that day, December the 20th. Ontario's letter was delivered a week later. This is right around the Christmas period. Their letter was not delivered till a week later, December 27th. But it is the case that the offers, the amount of the offer was made by Ontario the same time as Canada's, which was they would match that. They would also pay 1.5 billion.
How was it made? Was this at a meeting?
The offer? No, the offer was made in writing, I believe, and I'm not sure.
So separate from their December 27th letter.
Let me see if that's in the record. Yes, it is. So at tab 47 is Ontario's letter, and you'll see that it's dated December the 20th. Do you have that? I think my colleague's trying to bring it up on the board.
I'm just trying to figure out what you said. You said Ontario came up with their own offer a week later, December 27th.
No, they came up with the amount. They wrote this letter on December 20th saying, we're going to pay 1.5 billion, but we'll tell you why later.
Okay, got it.
And it took them a week to get out their letter, which is a very lengthy and comprehensive letter. And
Yes.
as I did note, it was the Christmas period. I'm not faulting them for that or asking you to draw inferences about it. I'm not asking that. But you don't need to draw any inference about what Canada did because Canada is explicit about it in its letter. Canada rationally explains.
I'm just trying to figure out the timing. So Canada's offer independently worked at was 1.5 billion.
That's right.
And on the very same day, Ontario released their number.
Yes, and it was 1.5 billion. Now, this
Is that a
doesn't
coincidence?
It's not a coincidence in the sense, I'll admit, although it's not in the record, that before, I mean, I think it's an inference that Mr. Gover used a phrase, it would insult our collective intelligence to assume that it was just a coincidence. So although it's not in the record, I can tell you that prior to setting out its December 20th letter, Canada told Ontario what it was intending to pay. So
Ontario says, okay, we're going to match that. And we'll tell you, we'll give you our.
And I can't speak to Ontario's process. Canada and Ontario, certainly I can tell you from Canada's perspective, Canada told Ontario what it was intending to offer. Ontario, and I believe Canada, I would expect, and I can't recall, but probably would have told Ontario that Canada's offer would be conditional on Ontario matching it or exceeding it. And so the same day that Canada set out its December 20th offer, Ontario had an offer that matched. It's up to Ontario to explain how they arrived at their figure. Canada did not rely on Ontario to arrive at Canada's figure.
I just want to be clear, although I appear to be very interested in this coincidence, I don't know that anything turns on it, but it does keep tripping me up.
Yes. And I'm hoping that it helps you, Justice Hennessy, to know I'm not trying to hide anything here. I'm admitting to you that when Canada made its determination, it told Ontario before it sent out its December 20th letter. Although, as I said, that's not in the record, I can tell you. As I said, it's an inference that has certainly been drawn. It would be a remarkable coincidence if there hadn't been discussion between Canada and Ontario about that. But that doesn't mean that Canada based its decision on what Ontario was doing. And in fact, the record shows the way that the two crowns came up with their figures were completely different. And I've just finished going through how Canada arrived at its figure and why Canada's approach is rational. You'll have to consider Ontario's approach separately because Canada takes the position and took it in December of 2024 that it's Ontario's responsibility to determine its own assessment of what it owes. And at that time, Canada communicated that it expected Ontario to pay at least as much as Canada. That was in those words, it's conditional on Ontario matching or exceeding. Canada expected that Ontario would pay at least as much as Canada.
Thank you.
Now we have about a month then of continued negotiations with the First Nations. And you'll see in the record, there's further exchanges of correspondence. The Minister of Crown Indigenous Relations, the Honorable Gary Anandasangari, attended in person, as did the Provincial Minister, the Honorable Greg Rickford, actually attended some of these meetings. And then we moved from a negotiation into a mediation. This all happened in January. And as you know, through the materials of the parties, there was a 2-day mediation with Madame Janice Charette, former clerk of the Privy Council and ambassador to the UK. She was the mediator. We had this mediation. Ultimately, it was unsuccessful, and Canada was required to exercise its discretion. And that is Canada's January 27th letter. So that's the next thing I want to look at. So in its January exercise of discretion, Canada revisited scenarios 1 and 2, which it now lumped together because they really are the same. Canada's now acknowledged that the honorable thing to do is to pay 50% to the First Nations. So Canada revisited the scenarios 1 and 2 and scenario 3, which was Mr. Hutchings' full NCRR at the band trust account rate. Now, Canada had to reconsider what it had done with scenarios 1 and 2 because the original calculations that Canada had done were based on the materials, the numbers that Smart and Bodway had presented at the stage 3 trial, where their total NCRR was minus $4.6 billion. So Canada noted that, well, Smart and Bodway, through this engagement process, there's been a further exchange of expert reports. Smart and Bodway have a new position. Now their position is that when they take another reconsideration of reforestation and firefighting expenses, they now say, instead of a total NCRR of minus 4.6 billion, they're looking at a positive NCRR of 375 million. And that you will find
that. When did the new Smart and Bodway numbers come in?
It's addressed at page, and I don't remember off the top of my head when those numbers came in. I can easily find that in the record if you give me a moment. But I think it might actually be in Canada's letter. Yes, it says, I'd like to turn up Canada's letter. Oh, I think my colleague already has it. Yes. So I'm looking at page 13 of Canada's January 27 letter, page 25 of the record. It says Canada's revised assessment of compensation, and it says, since Canada's offer of December 20, it's received feedback and also new information. Ontario has made adjustments to its position and no longer relies on its expert stage 3 estimate of minus 4.6 billion. It goes on to say, in its letter of December 27, Ontario advised that revisiting the economic evidence, the net economic benefit to the Crown from 1850 to 2019 is up to 375 million.
Is that about a $5 billion difference?
Yeah, I guess so. I'm just quickly doing the math. I would agree. But from this, it appears that it appears, certainly the way that Canada cites it in Canada's letter, that this information came to Canada's knowledge on December the 27th. And I'm sure that my friends will correct me if, in fact, Ontario presented those numbers earlier. But I recall, I believe it's noted in Canada's letter here that it was the December 27th letter of Ontario that showed that movement, the change in figures. Again, I said I'll leave it to my friends if they can show me somewhere else in the record.
And this is what page of the letter?
And this is Canada's January 27 letter, page 13.
Thank you.
Page 25 of the record. So then this means Canada had to reconsider, well, it doesn't have to reconsider scenario 3 because that's already based on Hutchings' full numbers. But it does have to reconsider that scenario 1, 2, that whereby Canada arrived at a figure of 2.51 billion. So Canada reconsiders that and determines that it's at the bottom of that same page, page 13. Canada has revisited since 1 and 2, which used Ontario's former estimate of minus 4.6 billion. And in response to this change in the evidence, Canada notes that we looked at this before when we looked at Canada's written closing submissions at the stage 3 trial. Canada looked at a bunch of different ways, a few different ways, I should say, of arriving at a figure somewhere in between Hutchings and Smart and Bodway. Canada said, well, you could look at the midpoint. That doesn't seem good enough for the First Nations. Let's look at a figure 2/3 of the way to Hutchings. Let's look at a figure 3/4 of the way. Let's look at a figure if you assumed Smart and Bodway were at 0 as opposed to a negative number. And all of these figures gave us a range of between 4.4 billion and 5.5 billion. If you remember, we went through that. If you're hopefully still following me. So Canada determined with this new figure of a positive of 375 million from Ontario, does that alter Canada's assessment? No, it doesn't. In fact, the 375 million is really quite close to that scenario that Canada considered where let's just assign 0 to Smart and Bodway. Let's not have any negative numbers. What's the midpoint? Then it's 4.4 billion. So even with this new evidence from Smart and Bodway, the numbers that you arrive at are lower than what Canada had already committed to as determining to be fair compensation. This new number doesn't change Canada's assessment that $5.5 billion is a reasonable amount of NCRR on which to base its determination. And Canada explains, Justice Hennessy, that the reason Canada originally took a figure that was either 2/3 or 3/4 closer to the Hutchings numbers than to the Smart Boldway numbers, because Canada was concerned that Smart and Boldway were too aggressive with their expenses. And in fact, Ontario's new information that it was too aggressive on reforestation and firefighting, and the real figure is not minus 4.6, but actually 375 million. That just really vindicates or confirms Canada's position that the right amount of NCRR is closer to what Hutchings had estimated, somewhere closer to Hutchings. And Canada remains, after conducting this analysis, remains of the view that $5.5 billion is a reasonable figure to assess the global amount of NCRR to be shared.
And what is one to make of the fact that it took from the stage 3 cross-examination and arguments to whenever that was, let's say it was the summer of 2023 till the final days of 2024 for Smart and Boldway to say, oh yeah, maybe we were too aggressive?
That's something that Ontario will have to address, Justice Hennessy. I can't speak.
In an honorable engagement process.
Again,
but Canada is also relying on those numbers. So you say that's Ontario's answer, but those are your numbers, and you were at the trial. Canada was at the trial.
When you say those are our numbers,
they're the numbers Canada uses to come up with scenarios 1, 2, 3. They're the numbers that Canada uses to consider one of the factors. What are the Crown benefits?
Yes.
So that's why I asked the question to you. I'll ask that question to Ontario, but Canada says to the First Nations, either throughout the engagement process or in their December 20th letter, these are honorable numbers. For whatever reason, the economists who came up with them admit, before perhaps their lawyer teams, that maybe those numbers don't stand up to scrutiny. Maybe they're just not that honorable. Am I going too far with what
Well,
an outsider might say, looking at that experience?
I can answer from Canada's perspective. And Canada's perspective is Canada is taking information. It doesn't have its own information on resource revenues because they're not Canada's resource revenues. It's taking information
This is an 1875 argument, but go ahead. Canada says we never had the information.
Yes, it's the same problem it was the same problem that the parties dealt with back in 1899, at the time of the Dominion Provincial Arbitration, for example. So yes, it is the case, and this is a breach. This is Canada's breach, and we admitted that breach in the stage 3 closing submissions. Why should Canada pay 20% if Ontario collected all of the revenues? Why shouldn't it be Ontario with 100? Canada admitted Canada bears liability because it failed to follow up with Ontario on behalf of the First Nations. Canada admits that. That is a failure. So I'm not intending to use it as an excuse.
Wondering, is that any different from me listening to you in 2025 saying, we saw what happened, but we didn't have any better numbers?
No, I think, Justice Hennessy, this is why it's different. Canada looked at both the Smart Boldway numbers and the Hutchings numbers and took both of them with a measure of scrutiny. Exactly as I said before, as a judge would. You weigh the evidence, you assess reliability and credibility. And Canada did not assess the Hutchings numbers as being completely, not everything Hutchings and said. Okay, let's just talk about Smart Boldway. Smart and Boldway, it is, I'm trying to find the right adjective. Maybe I should use one that you used. Yeah, it's problematic. I would agree with you. It's problematic that Smart and Boldway changed their figures that much. And remember, they also changed them from originally minus 7.9 billion up to minus 4.6 billion, and then now positive 375 million, right?
So that's 12 billion.
Yeah, but look at it this way. it shows the evolution of Smart and Bodway's thinking when they're cross-examined and given the reply reports from Hutchings. Another way of looking at it is it's reasonable that Smart and Bodway, faced with new evidence and new arguments about their reforestation and firefighting expenses, said, let's take a different approach to this. Let's concede some of these issues. Responsive, this is a give and take process. Let's be responsive to the criticisms that we've heard. And let's change our numbers. From Canada's...
I wasn't asking about the economists.
I'm sorry?
I wasn't actually asking about...
Let me try it this way.
No, I wasn't asking about why did the economists change their numbers. I was asking about Canada saying, we saw that cross-examination in 2023. We have gone through a 6-month engagement process where the Crown benefits are front and center. And I think what Canada is saying is we didn't ask for new numbers. They're not our numbers.
I'm sorry.
And we didn't ask for new numbers. And I say,
I haven't got
that the 1899 case?
I'm sorry. I have two answers to that question. One answer is what I've already told you. Canada, these new numbers vindicate Canada. Canada always felt that Smart and Bodway were too low. And these new numbers are a vindication of Canada's approach. The second argument I wanted to make was Canada isn't actually relying just on these Smart Bodway numbers. Knowing that the Smart Bodway numbers are problematic, Canada said, let's look at scenario 3. Forget Smart and Bodway entirely and look at Hutchings alone, his full NCRR at the BTA rate. So those are the two answers that I should have gotten to earlier. Number one, Canada always took the position that Smart and Bodway's numbers were problematic, and their movement only vindicates Canada's position. That's explained in Canada's January 27 letter. And two, Canada looked at another alternative scenario, which was the full amount of Hutchings NCRR. So that's how Canada addressed that.
Thank you.
Now, I had left off describing how this actual change from minus 4.6 billion to 375 million doesn't change Canada's position because, as I said, Canada had already factored in the fact that Smart and Bodway were too aggressive with their expenses. And even with Smart and Bodway's new numbers, Canada's assessment that 5.5 billion is a reasonable approach stands. Now, remember, that's only one of the scenarios Canada considered because it also considered the $11 billion that Mr. Hutchings proposed. So the difference, Canada then, the difference between December 20 assessment and the January 27th letter is, of course, readily apparent, $600 million. Because Canada moved up its assessment of total compensation from $3 billion to $3.6 billion. And Canada explains this additional $600 million at page 3 of its letter, 15 of the record. Canada describes that its determination to pay $1.8 billion plus costs, this is a move up from its offer of 1.5, represents an increase of 300 million from Canada's offer to settle and 600 million globally, totally. And it says that this increase has been made in response to further information and perspectives we have heard from the First Nations since December 20th. This includes information and perspectives that were shared with me directly, this is Minister Ananda Sangari, by the chiefs during our meeting on January 15. We have heard the impacts that the nature and severity of the breach have had on the Superior First Nations and the great needs of their communities. In response to this, Canada has determined to increase the amount of compensation to be paid from Canada's December 20th offer. So, I put in the outline, just so you can see the comparison, where Canada moved from its stage 3 trial position being 2.45 billion Then its December 20th letter of offer was 3 billion. And then its January 27th exercise of discretion was 3.6 billion. Now, a question you might have, Justice Hennessy, is what were the compromises that Canada made that came out of the engagement and negotiation sessions that changed Canada's perspective from the stage 3 trial? Shouldn't there have been changed perspectives and compromises? And my answer to that is, admittedly, there's not a lot of change because Canada took an honorable position at the stage 3 trial when it proposed the figure of 2.45 billion. That was the high end of what Canada had proposed would be appropriate compensation. So Canada's position has changed from 2.45 to 3.6 billion. First of all, I would say that actually is an increase of over 1.1 billion. Now, of course, some of that is going to be interest, right? But it does represent an increase of over $1.1 billion. And Canada did make compromises, such as it abandoned this idea that it would only pay the First Nations 20% of the total liability. And less significant, but of concern to the First Nations, was Canada did a benchmarking exercise to ensure that its determination of honorable compensation fit within benchmarks. And one of the benchmarks it used was the one that it used at the stage 3 trial. Well, what would the First Nations have received if the Crown had been able to pay $10 all along? And Canada agreed to abandon that as a benchmark at the First Nations request. So the next topic I want to go to is what I've listed as 2 sub E, which is the relationship to the RHT settlement. Now, I have in mind, and I know my friends have said, my friends may say what Canada has done is engaged in a process of cherry picking to arrive at a preconceived idea of what is honorable compensation. And that preconceived idea is based on the $10 billion settlement with the RHT. That's what my friends have suggested, if not outright said. This is cherry picking to arrive at a preconceived idea. But Canada developed its position that honorable compensation for the RST was in the range of $2.5 billion prior to the stage 3 trial and prior to the RHT settlement. And this is evidence from the fact that Canada the Crown made an offer to settle to the First Nations prior to the stage 3 trial of $2.5 billion. This is probably news to you. It's in the record at tab 110. It's minutes from one of our, it appears a couple of times in the record, this acknowledgement that the Crown had made a pre-trial offer, but the precise amount of the pre-trial offer is recorded at this particular minute. The date of that one again, January 6th. This is the January 6th minute, and it's noted that one of the chiefs had noted that she expressed her disappointment with the low offer of $3 billion, noting that the previous offer made prior to the stage 3 trial proceedings was already insufficient at $2.5 billion. So it is the case that the Crown made an offer of $2.5 billion before the stage 3 trial. And it is also the case that Canada's opening.
And sorry, it doesn't matter what.
These are minutes of January 6th.
January 6th.
2025.
What year?
2025. Yeah. This is the engagement and negotiation process that picked up after the December 20 offer. So the First Nations now have this $3 billion offer combined from Canada and Ontario. And the response of the First Nations is, $3 billion is not enough. It's hardly more than the 2.5 billion you offered before the trial. Right.
Thank you.
Yeah. So we note Canada notes in its factum, and I think I referred you to this earlier, that Canada's position on how its methodology for determining the amount of honorable compensation was based on the same formula it's used since the outset of the stage 3 trial. And we put up on the board, I think we put up on the board, and if not, we'll do it now. Part of Canada's opening statement from the stage 3 trial. That you can access at factum footnote 137. And my colleague has put it up on the board. So this is the outset of the stage 3 trial. Canada's already offered 2.5, I should say the Crown combined offered 2.5 billion. And Canada is explaining at the opening that, first of all, Canada goes through why it rejects economic rents and why it rejects 60-40 in its opening statement, and goes on to say, Mintz and O'Riordan agree that a 50-50 approach is one reasonable approach. And also this point about roughly 10%, a population-based approach is worth considering. So what we're looking at here is that Canada's position hasn't changed, Justice Hennessy. Its methodology hasn't changed. It's taking NCRR, not economic rents. It's taking a bring forward rate that's not 60-40, and it's taking a share somewhere between, now in the opening, we said between 10 and 50%, but by the closing, we changed that to 20 to 50%. But you can see that this methodology was in Canada's mind from the outset. And what I'm suggesting to you, Justice Hennessy, is it's reasonable to conclude then that the Crown's offer of 2.5 billion bears a relationship to this methodology. And in fact, I've shown you in the stage 3 submissions exactly how it bears that relationship. Now here we're going to get a little bit tricky, because there was a change in Smart and Bodway's number from pre-trial, when it was minus 7.9, to the actual trial, when it was minus
3.79 billion.
7.9 minus 7.9 billion was the pre-trial expert reports of Smart and Bodway. Then at the actual stage 3 trial, they said, they made some adjustments and said, no, it's minus 4.6 billion. So again, you may say, well, look, if Canada took the position that it's going to take some share of NCRR brought forward at something like the bond or BTA rate share for the First Nations, well, and that miraculously ends up at 2.5 billion, and that's what the Crown offered before trial. Well, actually, Canada, no, that's not comparable to what you offered at the stage 3 closing, because in fact, the point you made earlier, Justice Tennessee, but the Smart Bodway numbers changed. Well, when you take a look at that change, it really doesn't make much of a difference. When you're looking at Smart and Bodway's minus 7.9, and now it moves up to minus 4.6, when you're trying to find a number somewhere between the two that's closer to Hutchings, whether it makes the difference between that number is actually less than $1 billion in terms of where it moves the needle on the spectrum.
When you're saying when you engage in that exercise of looking for a midpoint,
of looking for a midpoint or something, the move from, roughly minus 8 to roughly minus 4.5, it's roughly, let's say 3, and half of that is roughly 1.5. But we're not looking at half; we're actually looking at more towards Stiglitz and Hutchings, right? So the actual effect is not that different. And if it makes you feel uncomfortable, think about it this way. Canada took the position that even if Smart and Bodway were at 0 instead of negative, let's say Canada said, we're not even going to look at negative numbers. Let's assume it was 0. And we showed you that if you look 0 compared with Hutchings 8.9, the midpoint is 4.4. But Canada's already done its assessment on 5.5. Are you following me?
Yeah.
Okay. So, it's kind of ironic, I recognize, because I'm taking you through all these mathematical calculations at the same time that I've been telling you it's not
a
mathematical exercise. It's not a precise mathematical calculation.
Brain twist also happened to me throughout stage 3.
Yeah, it's not a precise mathematical calculation, but these are the numbers that we have to work with. And Canada deliberately takes a holistic view that accepts some bits of this expert and some bits of that expert, which isn't cherry picking. It's weighing the evidence and assessing reliability and credibility. So where we end up with, I submit, Justice Hennessy, is you've seen that the Crown came up with a $2.5 billion offer. Canada explains in its closing submissions how it arrives at 2.45 billion, roughly the same. And that's based on this methodology. Now, interestingly,
You say Crown came up with 2.5 billion offer. That's the pretrial offer.
that's correct.
And then at trial, you came up with, in closing submissions, with 2.45.
That's correct.
You say that was because the same methodology.
Yes. We're off by 50
That's
million. It's roughly the same.
It's roughly the same number. But could that not also be, we didn't do anything? We had already made that offer. So here it is again.
Yep, it could be. You could say that Canada hardly made any change at all. What was the point of the trial? Canada didn't change its position throughout that whole trial. What was the point? You could say that.
I'm hoping you're going to answer that.
And I am.
I didn't want to ask.
So it's not that the stage 3 trial had no effect on Canada's position from the opening to the closing, but the expert evidence was available to all of the parties before the trial. And sure enough, both Hutchings and Smart and Bodway made revisions during the course of the trial. It's true that Smart and Bodway's revisions were more significant than Hutchings' revisions. But keep in mind, of course, Canada had already taken it into consideration, its conclusion that Smart and Bodway were probably too aggressive with expenses.
Pre-trial?
Pre-trial. And that I'm saying is demonstrated by the fact that the pre-trial figure lines up with the post-trial figure, and the post-trial figure is plainly based on a figure that's closer to Hutchings than to Stiglitz, than to Smart and Bodway. And again, I know that one of Canada's benchmarks to determine that 5.5 was reasonable, and therefore, half of that would be 2.75 minus 300 already paid. That's where we get the 2.5, right? That was, the 5.5 was one way of looking at the NCRR. And remember, one of those scenarios Canada considers was, what if Smart and Bodway was at 0 rather than a negative number? And even that was at 4.4. So Canada's already taking an approach that favors the First Nations. So now we get to the RHT settlement. It is known that the RHT settled for $10 billion, which happens to be 4 times as high as the 2.5 that was offered to the RST. And all of the parties know, and it's in the record before you, that Hutchings assessed the NCRR in the Huron territory to be 4 times that of the Superior Territory.
I made a note to ask you, was that in the stage 3 record?
It was not in the stage 3 record, but it's in the record of this review. And I can show you where it is. It came out also of the fact, well, this is what we talked about. Do we need to put those RHT expert reports in front of the court in this hearing? And we determined that we don't, because all of the parties agree that the Hutchings numbers for the RHT were 4 times as much. And where you'll find that in the record is Mr. Schachter's letter of November, it's tab 29.
I rise on a potential objection. I'm not sure if this is, I will leave it to my Huron friends to comment, but I had thought there was some concern about getting into numbers as it affects the Hurons, and I will let them speak to it if they want to. I just want to alert the court to this sensitive area.
Thank you.
Thank you. And I am aware that it's a sensitive area, but my understanding from our discussions at case management conferences was it wasn't necessary to put the reports of the RHT experts into the record, but that all of the parties, the overall numbers were not a contentious issue, and they are in the record, and that all of the parties agreed with those numbers.
I'm just wondering if there's a...
Well, there's a bit of ambiguity about where we left this part of it. it's our view that those numbers were privileged. They were numbers that were submitted for the purposes of the litigation, the Restool litigation. That litigation is ongoing, but they were never filed in court. And so they retain their litigation privilege. However, Ms. Evans is correct that those numbers found their way into the record of this review because they were used by the parties in correspondence during the engagement session.
That particular last statement being the proportion, the difference between, I don't know what you say, revenues?
There's a letter in the proceedings where they set out some information about the RHT numbers. And we say they shouldn't have been using the numbers that way. They shouldn't have been because they weren't available. They only had access to them because they were shared in the context of litigation and they shouldn't have been used. But they are in this record.
Thank you. Not happily for you, not happily for the RHT.
No, we think it was a breach of litigation privilege for them to be included.
Well, what do you say? I don't want this to be a problem, is what I'm trying to get to. What's your purpose in putting that in?
The purpose in putting this in is it demonstrates that it's not correct to view Canada's determination of compensation for the RST as though it derived from the RHT. And instead, one could look at it that both were assessed, both were assessed and by Canada. And it turns out that the RST assessment was 1/4 of the RHT assessment. And the evidence before you, which was put in by my friend, Mr. Schachter, not by either of the Crowns, although once it did make its way into the record, Ontario, for example, cites it explicitly in their decision letter of January 27th. Canada's a little cagier about it in its letter, being sensitive to the fact that this might not be something that should be public. Canada said there's a certain percentage, a certain value that the First Nations are aware of. This language may ring a bell for you. I can take you to it if you want. But Canada says, there's a certain value that, but the actual value where it first appears in the record is in Mr. Schachter's letter of November 21st, tab 29 of the record. At page 2027 of the record. Oh, sorry, November 1st. What did I say? I said the wrong thing.
No, November 21st.
November 1st, sorry. November 1st, 2024, tab 29 of the record.
Yes.
Page 2027 of the record is where Mr. Schachter notes, because Mr. Schachter was looking at ways of comparing the RHT settlement, different ways than
per
capita. And he noted that in the data presented for the RHT, which the Crowns have in their possession, and his footnote 16 notes, this data is found in Hutchings and Stiglitz reports for stage 3, shared with the Crowns, but ultimately not entered into evidence in stage 3. We expect that for the purpose of the engagement and decision-making process, the Crowns will accept this data as being credible and reliable, as Hutchings and Stiglitz were with the RST evidence, as being as credible and reliable as Hutchins and Stiglitz were with the RST evidence presented. If the data is anyway doubted by the Crowns, please let us know. So here, the First Nations are communicating to the Crowns that the First Nations expect that the Crowns will have in mind the Stiglitz and Hutchings RHT reports, which all of the parties had. So whether it was proper for for the plaintiff's counsel to rely on this figure is not something that I will make submissions on, but the fact is it's in the record. The First Nations asked the Crowns to consider it. And what I'm saying is, Canada, this is evidence that it isn't a dispute that obviously the RHT territory had greater revenues than the RST territory. And as it happens, the differential was about 25%, meaning that the RHT was about 4 times as much.
And the number, when you say 1/4, it's revenues or NCR?
Actually, the way that it's presented in this letter is with economic rents.
Sorry.
So I am a little concerned here because there's nothing we can do about it being in Mr. Schachter's letter. I think what Ms. Evans is doing now is she's trying to take you back someplace else before that letter was ever written. Ask you to draw conclusions about what was happening in Canada's mind back then. And she's using this as evidence of that. And that's what we think is improper. So in our view, this whole line of submissions that you should draw some inference about what happened with respect to RHT from this sort of information is improper given the nature of the global settlement there.
Okay.
I think Ms. Evans has made her point. I don't know if she needs to keep going on about it.
Yes, the only other point that I need to make, and it's made in Canada's letter and it's made in my notes here, is none of this speaks to what the RHT thought when they entered into a $10 billion settlement. Canada makes that point clear in its letter of January 27, and I'm making that point before you again today. And my friend acknowledged in her submissions, Ms. Boyce Parker did, that Canada is not saying that you should draw any conclusion about what led the RHT to agree to a $10 billion settlement. The evidence that all that Canada is putting forward and did in its January 27th letter is the really actually asking the court, inviting the court to draw the inference that the RST settlement did not arise out of the RHT settlement. It just so happens that they both can be explained in a similar way, one being 4 times the size of the other. That's Canada's perspective on it. And
Sorry, I just want to be clear. Maybe you and I could talk about this at the break before you go on any further. I thought we had an agreement that the settlement discussions, what happened in settlement was privileged.
yes,
So it sounds to me like you're skating dangerously close to explaining Canada's position, which sounds like a breach of that privilege.
Which I think brings us to a break. As we have done often. I'm sure you can work this out. Is 15 minutes long enough?
yes.
Thank you.
This court is to down for 15 minutes. Court is resumed. Please be seated.
Have you come to some,
I'm ready to move
have you
on.
come to some approved script or?
I'm ready to move on.
Okay. Are you moving away from the RHT discussion?
No, if you look at my outline, the RHT discussion comes up twice, and once was discussing the relationship of the RHT settlement to the Canada's determination of the exercise of discretion there, sort of chronologically.
Yeah.
But as a separate issue, I will be addressing later, probably not till tomorrow, the RHT settlement as a benchmark. And I'll be addressing things, for example, like parity. You asked questions about to what extent was parity important.
Yes.
Mr. Gover took you through reasons why the risk situation was different at the time. And those are the things I'll be addressing under that category.
All right. So I'll ask this question now and you tell me if it works better now or under number 3 on your outline. And that is, does Canada say that the RHT settlement is relevant because it's an important that parity holds some value for Canada or some importance or some usefulness?
I will be addressing that I'm gonna
Okay.
get to it, but I'll just tell you the short answer. Canada doesn't place the same importance on parity as I think Ontario does. Canada is explicit in its January 27th letter that Canada agrees with the First Nations that parity should not be a goal. Parity with the RHT settlement should not be a goal on a per capita basis, should not be a goal of Canada's exercise of discretion. In fact, the more relevant consideration is their relative productivity of the land. That's what the treaty says, if the territory shall produce an amount. So it's parity is not a goal, but Canada does go on to say that in determining this, holistic view, Canada determines that the amount of compensation should not be substantially different on a per capita basis as the RHT.
And so that's my question. Why is that? Why does Canada value not having a difference, whether they're on whatever metric? If you choose a metric that should be used in some way, why is it important to Canada that you have some way to bring those two settlements into a realm that you say is similar or not different?
Mm-hmm. Yes, and I don't think Canada's really clear on that in its letter. As I said, I was intending to get to it later, but it's paragraph, it's on page 36 of Canada's letter. We can pull it up later to go into greater detail. It is true that Canada simply says that Canada considers that the total amount it has assessed to pay should be reasonably comparable on a per capita basis to account for their needs, despite the fact that the productivity of the Robinson and Superior lands was lower. So I think
it's the should be is my question. Why should it be reasonably comparable?
Well, it's not articulated clearly in Canada's letter, but I think the answer, Justice Hennessy, is that it's one of those social considerations. When you talk about polycentric considerations, it's a social and policy consideration that it would not appear, if we're looking for a number that is overall fair, reasonable, honorable, Canada's conclusion is it wouldn't be fair, reasonable, honorable if it was significantly different on a per capita basis.
Thank you.
All right. So where I wanted to go now is still under the category 2 about how Canada exercises discretion. I told you a couple of times I'm going to get into Canada's approach to these drivers of the gap, the $30 billion gap. So I want to address NCRR versus economic rents or a portion of rents, Canada's approach to present value, and Canada's approach to share. And I want to start by saying Canada's approach was honorable from the beginning. It was based on expert evidence and Canada's determination to rely on some of that evidence and to reject other parts of that evidence, as I've noted before. That's not cherry picking. It is making assessments on the evidence and using good judgment. And the point here is that, as I said earlier, economists are not scientists. They work in theories and with assumptions to make predictions. And I don't have the site for you right now, but Mintz and O'Riordan in particular use that language. I thought I had it in my compendium, but I don't. But all of the experts talk about the fact, even Stiglitz and Hutchings, when they talk about using economic rents, these are theories and approaches that, one of the points that came up during the negotiation and engagement sessions, economic rents don't appear on a balance sheet. They're based on a theory that can be, applied. So the whole point is all of these experts are using assumptions and theories. And this brings me back to when I was a first-year economics student in university. My economics professor told us a joke that has stuck with me forever. And in debating whether or not I could pull off a joke, I determined that I couldn't, but I did, to make sure I had the joke right, Google it. And sure enough, there is a Wikipedia page devoted to this concept, which is called Assume a Can Opener. And the joke goes like this. Stranded on a desert island are a physicist, a chemist, and an economist. And all they have between them is a can of beans. And the physicist says, I know how to open the beans. We throw it at a certain velocity, at a certain distance, and it'll smash into the tree and break open, and we can eat the beans. And the chemist says, no, we'll lose too many beans. I have a method. We heat it up to a certain precise temperature, and then it will explode, and we'll get the beans. And the economist says, no, I have a method. There'll be no fuss, no mess. We won't lose any beans. Assume we have a can opener. And I'm glad you laughed, because when I told that joke to Jack Mintz, he didn't laugh. But in fact, there is a Wikipedia page devoted to this concept. It's now become a catchphrase used to mock economists and other theorists who base their conclusions on unjustified or oversimplified assumptions. I've included that at tab 2 of our compendium, because it makes the point that all economic work is based on assumptions. Economics is not a science. It is reasonable and it is good government policy to consider all of the approaches, not to throw out the baby with the bathwater, but then to take an informed approach that is a blend of these different economics approaches, and that favors those that make more sense. This kind of approach is especially important and justifiable when the Crown has myriad other obligations and non-economic factors to consider, such as reconciliation of Indigenous and non-Indigenous people who are also treaty beneficiaries. So with that in mind, I want to look at these three drivers. The first one is Canada's approach to NCRR versus rents. And I don't want to go through the submissions that we made at the stage 3 trial, but I will summarize briefly, because it's summarized in Canada's January 27 letter, some of the high points as to why Canada rejects the economic rents approach. It's set out in the
If it's much more than what I heard at stage 3, well, if it's more than what I heard at stage 3, it's too much. But it should be condensed well, because I'm very familiar with those arguments.
And I'm glad to hear that. I do have it highly condensed, and I think it would help the flow of my argument if I could briefly go through it.
Please do.
And I won't bother directing you to the record. I'll just say Canada rejects the economic rents approach. It's too theoretical. It's based on the assumption that there is or can be a perfect market where players can sell their goods and services or their capital at perfectly competitive rates. And that once everyone else has their perfectly calibrated returns or profits, excess profits can and should be collected by the government. Hutchings estimates what those rents were by using statistics and assumptions about what the competitive rates of labor and capital would have been, and therefore what would have theoretically been left over, which the Crown let other actors collect in the form of profits that were too high. Now, Mintz and O'Riordan made reasonable criticisms about the assumptions Hutchings made. They went into, for example, criticisms related to transfer pricing, which was a relatively complex
esoteric
issue, but both Smart and Bodway and Mintz and O'Riordan had this concern about transfer pricing, and I won't go into it, but I just direct your attention to that concern. Mintz and O'Riordan also brought out a concern about the assumptions that Hutchings made about competitive rates for capital. And they pointed out that there certainly was historical evidence to suggest that there wasn't a lot of hope for the productivity of these lands. And for that reason, Hutchings probably used an assessment of returns on capital that was probably not appropriate in Mintz and O'Riordan's view. Now, all Crown experts took issue with the assumption that the Crown could have or should have taken the excess profits for itself, because there are other policy reasons the Crown considers in setting tax rates, and it's through taxes that the Crown collects these rents, including encouraging economic activity and preventing tax avoidance and fraud, which was a point that Smart and Bodway articulated in their report. Now, how it's relevant now, Justice Hennessy, is the plaintiffs now say, well, if you don't accept economic rents, then at least give us indirect capture, the 25% difference between NCRR and economic rents, on the theory that, you know, at least some amount of the economic rents the Crown probably captured through taxes. Canada rejects the indirect benefits approach. And Canada explains in its January 27 letter why. In short, it's based on the economic rents approach. And for the reasons that I just summarized and that were articulated at stage 3, Canada rejects economic rents as an approach entirely. So,
But isn't the alternative position of the plaintiff's taxes an approach that does not suffer from the criticisms of rents?
no, it does suffer from the same criticism, Justice Hennessy, because these taxes, again, what the plaintiffs are doing is they're taking Hutchings numbers, Hutchings estimates of economic rents and saying, let's just take 25% of those. We're still talking about economic rents that have been arrived at through this theory that there is such a thing as excess profits, that the Crown could have, conducted its affairs differently.
I didn't understand it as that. I thought it was just an estimate of tax.
An estimate of taxes. Yeah, I stand corrected. It is an estimate of taxes, but Canada doesn't accept it because it is still, it's still a theory about what Canada or Ontario, what the Crown collects by way of taxes. It's not a well-supported theory about whether it's 25% or 30%. Canada wasn't persuaded by Mr. Hutchings' new expert reports that were delivered during the engagement and negotiation session.
Can I put those two sentences together for you? Or do you say it's not well supported in the Hutchings report?
It's not well supported in the Hutchings report. Now, Ontario solves that problem by saying that, we're not going to accept a share of economic rents, but we'll just, accept some kind of indirect capture, and we'll value it by saying we'll take 25% of NCRR. Really, I think one of my friends described that as a super share. Instead of 100%, it's 125% of NCRR. And I made the point earlier, Canada doesn't find that logical, because Canada's position is the entire logic of indirect capture is Canada rejects that approach of indirect capture. That's because
Does it reject the notion that there's tax on income of resource extractors?
no, Canada does concede that that the Crown, and in fact the experts did, the Crown collects indirect capture through taxes, corporate taxes, and income taxes. Canada isn't convinced by Hutchings' analysis that it's 25 to 30%, but more fundamentally,
That's a number problem.
Yeah.
Just a concept.
More fundamentally, Canada doesn't accept indirect capture because it gets back to what did the treaty intend? And the treaty speaks about if the territory shall produce an amount. And Justice Hennessy, I'm not holding you to this, but you may remember at the stage 1 trial,
Go ahead.
you were afraid it would come up. It is
No, not afraid.
Okay, it's in the January 27th letter. It's not dishonorable for Canada to conclude that taxes on income and corporate income are too far removed from the productivity of the land, the productivity of the territory. We're talking about, income taxes are set for different reasons at different rates. It's not directly or closely related to the productivity of the land, is Canada's position. Direct revenues, which are the NCRR, are more linked to the resources themselves. They flow more logically from the treaty promise. They are more easily estimated. In fact, we saw Hutchings and Smart and Bodway had very similar numbers on revenues. It was only on expenses that they differed. And they're therefore more reliable. So this is,
I find this is a much easier argument than you don't accept rents, therefore you don't accept taxes. For all the for all the criticisms of rents.
and I understand the point that you're making, and I do concede that I mixed things up a bit there at the beginning when I suggested that that rents don't represent actual capture, because the intention of the rents analysis is to capture the indirect benefits the Crown receives. And some of those are through income taxes and corporate taxes. But what I'm saying is the whole concept of looking at indirect capture is in Canada's position, it doesn't logically flow from the treaty promise. It's not directly and closely linked to the resources. It's not as the figures just aren't as reliable. They're not as easy to calculate and estimate and link to the resources. Now, the other part of this argument that I want to address, Justice Hennessy, is my friend saying that Canada created false polls by looking at both the Hutchings numbers and the Smart and Bodway numbers. And I just want to note, Canada did not create the polls. Canada took them straight from the evidence. Canada created a way to assess them and to find a compromise position as between them, but Canada didn't create the polls. The polls were set by the different experts. And the next point I want to make is my friend argues, and certainly made this a very significant part of his position at the engagement and negotiation sessions, that Smart and Bodway were simply not credible and Hutchings performed much better at trial. Canada does not agree that Hutchings is as reliable as my friends do. I have to say he did a great job, but he doesn't have better credentials than the Crown's witnesses. He was better at testifying and at preparing helpful graphs, but he is literally a professional expert witness. Canada places at least as much weight in the highly credentialed and internationally recognized Canadian professors of economics who prepared expert reports for the Crown. And I've included in the compendium their CVs. I'm not going to take them to you, but it will just be a reminder that they are internationally recognized, have worked for a number of different international organizations and different countries, and have published textbooks and have excellent credentials.
And are you relying on Ontario's expertise, or are you?
Yes,
including-
Canada is. I'm including Ontario's experts, and I'm going to get into that in more detail. I do have to say that, like any of the experts, the Crown experts made mistakes. In some cases, they weren't good on the stand, and some of their ideas were not compelling, but some of them were. And I'm going to give you some examples of that. As we discuss in particular the next issue on present value and why Canada rejects the 60-40 approach. Now, Canada considered the 60-40 approach and wasn't persuaded that it was realistic and that it represented what would have happened absent the breach. This is a repeat of Canada's stage 3 argument, and I'm not going to go through it again. You've got that. But I do want to take a look at Stiglitz and Hutchings' opening report, which is in the compendium at tab 10. And my colleague will bring it up on the board. Stiglitz and Hutchings explained in their opening report, and I've got excerpts of it at tab 10.
Got it, thank you.
That the BTA rate, the band trust account rate, was one of two plausible alternatives to account for the time value of money in this case. So let's take a look at what they say. In paragraph 147, they discuss, there's two aspects really to an analysis of the time value of money. It's the time value of money and also the risk. Then they go on to say in paragraph 148, the objective of the calculation is to compensate someone today for money they should have received in the past. This requires us to consider the investment alternatives available to the Anishinaabe and what would have been done with the funds had they been received in a timely fashion. There are two plausible alternatives. Number one, first, that the money was invested at the same rates as what would have been paid had the Crown, as what would have been paid had Crown would held the money in trust. I think there's an error there. But the point is, One plausible alternative is the band trust account rate. They go on to say, second, and in our opinion, more correctly, the Anishinaabe would have invested over a long-term horizon. For example, had they been advised by a planner, and would have pursued a mix of equities and fixed income securities consistent with large investment and pension funds with long-term horizons, and therefore a 60-40 equity debt mix is appropriate. It's quite surprising, Justice Hennessy, when you look back at that initial report by Stiglitz and Hutchings, how remarkably briefly they address this issue of the bring forward amount. I've only included 2 pages. It hardly goes on beyond that. They have very little to say about it, except that there are 2 plausible alternatives, BTA or 60-40, and they go on to say, in their view, in our opinion, more correctly, 60-40 is right. And they explain that in the next paragraph. They say, individual investors and managers for individuals with high and volatile cash flow needs often invest in low-risk debt securities. Sometimes they're required to do so. They go on at the bottom of that paragraph 149 to say, such requirements and investment can be important for an individual who will retire only once and therefore is very much exposed to business cycle risk and short-term liquidity needs. There can also be trust issues around the manager, and having them highly regulated helps prevent investment managers making unwise investments. What Stiglitz and Hutchings are talking about here is what kind of people invest in lower risk investments. And I submit to you, Justice Hennessy, it's reasonable for Canada to conclude the Anishinaabe here fit the profile of low risk investors as described by Stiglitz and Hutchings. There can be trust issues around the manager is something that could fit within the risk profile of the Anishinaabe, as well as high and volatile cash flows. So Stiglitz and Hutchings go on to say at paragraph 150, in the opposite view, the 60-40 view, is that this is not the case for societal risk, for the risk confronting entities like First Nations or societies like the Anishinaabe, which is the correct framework for assessing the risk tolerance of the RST. The RST will never retire and need to call on all of its capital. It has a long-term perspective, like an endowment for the future. Now, Dr. Stiglitz was cross-examined on this point by me at the trial, and the cross-examination transcript is at the next tab, tab 11. And I put to Dr. Stiglitz, my question is, first of all, we went through the population. I don't know if you recall this, but we went through the population of the different First Nations. And just so you have it, Justice Hennessy, I included the population figures in the compendium as well. You don't need to look at them, but in case you wanted to, they're at tab 14. And what I did was I reproduced the evidence from the Big NAMI report, but it's way too small to read. So I also reproduced Canada's version of it, just for ease of reading. But I did want to include the Big NAMI one, so you know where the numbers, that they're actually in the record and where they come from. In any event, I had taken Dr. Stiglitz to these numbers, and I asked the question at page 824 of the cross-examination. So my question is, would a population of 33 people, or even 280 people, many of whom are children, might they be considered closer to a large family than a pension fund? And Dr. Stiglitz answered, when I approached the question, I didn't ask the question of how the funds were going to be managed. I just approached it as a collective for the First Nations in the RST. And so that particular issue of what happens if you have small subgroups and how you allocate it was not a question that I addressed. And I went on to say, if you'd been aware of or looked at the actual population sizes, would you not agree, I'm just paraphrasing here, that these are people who suffer the vagaries of life, like illness, unemployment, family breakdown? And Dr. Stiglitz goes on to say, well, yes, a family would, but I would hope that with notions of kinship and reciprocity, the First Nations would manage the collective as a whole. And for the collective as a whole, they would be able to manage this as a long-term investor, and they'd all be better off. The point I'm making, Justice Hennessy, is it's certainly reasonable, and I submit honorable, for Canada to conclude that they don't adopt, Canada doesn't adopt just Professor Stiglitz's analysis here. Because we know that the RHT, even today, are not acting as a collective of 12 First Nations or even 6 First Nations. The First Nations were living in communities that were remote and separated from one another. There is no evidence that they would have been managing it collectively. And most importantly, Professor Stiglitz didn't even consider that possibility. So this is just an example about why you can't take everything Stiglitz said as gospel. This is just a perspective. He also provides the perspective that the BTA rate is a plausible alternative.
Do you address the other argument that Professor Stiglitz made that investment in social capital has a return, he says, higher than 60-40?
Yes, I'll address that next.
Thank you.
So, in fact, I am going to address that, but I have another point that I want to make first, which is, on the other hand, we've got both Kersner and Booth and Smart and Bothway opining that a portfolio approach doesn't take into consideration risk. It provides a risky rate of return without any of the risk. It compensates the plaintiffs for having taken risks in the market that they did not take, and it assumes they never would have folded or taken their money out. Now, I'm getting to your question, but you'll see at the next tab of the compendium, I've reproduced Smart and Boldway's paragraph 40 of their opening report. And they explain in my tab 12, I'm sorry, tab 12 of the compendium.
Yes.
And I just introduced this by way of comparison to the Stiglitz and Hutchings approach, because I submit, Justice Hennessy, when you read this, it rings true. It makes sense. It's reasonable for Canada to adopt this approach, which is that the long-term Government of Canada bond rate is the best measure of the risk-free rate of return to savings in the long run. And they go on to explain that this concept about risk, that those stock market investments, their higher average returns include the risk premium to compensate investors for assuming the underlying risks, but the risk-free rate of interest best measures the opportunity cost of funds over time. And without reiterating the arguments made at stage 3, this paragraph, as compared with Stiglitz and Hutchings, what Stiglitz and Hutchings have to say, these are two different perspectives. And what I'm submitting to you, Justice Hennessy, is Canada is not required to adopt the Stiglitz and Hutchings approach in order to arrive at honorable compensation. Now I'm going to get to Booth and Kersner, because that is where the issue of social investments arose. It was Booth and Kersner who brought it up. So Booth and Kersner, their evidence is very briefly excerpted at tab 13 of the compendium. And Booth and Kersner explain, I think quite helpfully, this probability, this risk approach, and this Monte Carlo analysis, where you don't just take the volatility into account. You take you're not just taking a look at the expected average return. You're also taking a look at the risk. What if it was one? What if it was other? So it's a more complex analysis. Now,
Still in the criticism of the 60-40.
yes. But what Booth and Kersner do is, what I'm trying to say is, Booth and Kersner and Smart and Boldway had valid and compelling criticisms of the 60-40 approach. Now, my friends have said, okay, well, never mind that never mind the investment idea. Let's just say we'll use 60-40 because Stiglitz and Hutchings later go on to say, oh, well, it's a lower rate than the social investment rate would be. But I think it's important to note that Stiglitz and Hutchings never said a word about social investments when they wrote their opening report and said the two plausible alternatives were BTA or 60-40. It was Booth and Kersner who raised the issue of, well, some of this money would have been invested in social investments. And Booth and Kersner identified 3 categories.
But we should reject any evidence that was put to Stiglitz and Hutchings on social investment?
What I
Because-
say, no, because they did.
Your
respond.
expert raised it first?
Well, I do think it is relevant that when Booth and Kersner addressed it, they had a methodological approach to it. Stiglitz and Hutchings picked up the idea in their reply report without any detail analysis, without any assessment, for example, of what portion of unpaid annuities would have been invested at these different rates. They just make a general statement that social investment, yeah. Booth and Kersner suggest that, yeah, they use rates that are too low. We don't like the way they address depreciation, but no matter what way you slice it, it's higher than our 60-40 rate. So our 60-40 rate is good, conservative. And what I'm saying is that analysis is just a theory and a way of looking at things. It's not clearly articulated and explained, certainly not any better than Booth and Kersner did. And so what I'm saying is it's one piece of the puzzle to consider, but what I'm saying is it's not dishonorable for Canada to decide between the plausible alternatives, we prefer the PTA rate or the bond rate. These are, again, we talk about a range of honorable results. And I get back to the point about
The reason I'm perplexed here is that Canada put a lot of store in this. Look at spending. They put a lot of store in that approach, as you say, not just in this case, but previously. So Canada was invested in a certain approach.
now that approach.
So I'm perplexed because on cross-examination, that approach didn't do that well. As I recall, you disagree?
No, I disagree, Justice.
Okay.
Nancy. The
So
part of the
I
approach-
thought it didn't do very well, and I thought there was an answer to that. So all I'm saying, I don't need to go into how it fared well or how it didn't fare well. So I'll even step back from that. But Canada made a big investment in that investment approach.
Mhm.
And now you say, forget that approach.
No, I don't say that. And I'm sorry if I left that impression. And in fact, my friend said, oh, Canada backed away from the Booth-Kersner report. In fact, no, Canada hasn't.
I
And
thought you were doing that just now, saying, forget that.
No, I'm sorry, I haven't articulated this
Okay.
well. Let me step back. Booth and Kersner did what we called a tailor-made approach. They took guidance from the Ontario Court of Appeal in Whitefish, and where the Ontario Court of Appeal said, we're not just going to bring everything forward as though at a compound interest rate. The better way to look at it is, how would the money have actually been spent? And Booth and Kersner explained on the stand that they were then asked, by Canada, well, go back and implement this decision of the Court of Appeal. How would the money have been spent? And they looked at band trust accounts and came up with analysis. Well, some money is distributed to individuals. Certainly, we know here in this case, money was paid to individuals. That's because the treaty itself talks about an individual payment. Certainly, there was a belief that the individuals were entitled to an individual payment. So we know certain payments are made to individuals. Booth and Kersner go on to say some payments are consumed that have short-term returns, very short-term returns. They call that consumption, and they brought that forward at the rate of inflation. Then they said some other component is social investments in business infrastructure and human capital, being health and education. So I just want to make it clear. Booth and Kersner didn't say it's all social investment. They said what their analysis actually was let's look in every year how the balance was in the Dan trust account rate to come up with an approach that's based on every year about what share is money, saved, spent, invested in social investment. Some of it is consumed on short-term returns and what have you. So I just remind you, Canada is not saying throw out the idea of social investments. What Canada is saying is social investments are only one component. It's one component that Booth and Kersner looked at. And my concern about Stiglitz and Hutchings is, to me, it seems like an after-the-fact kind of idea. They pick up because Booth and Kersner raise it, and they seem to be suggesting that everything should be brought forward at the social investment rate. Whereas Booth and Kersner take a more, in my submission, logical and well-considered approach and say only some portions would have been invested at the social investment rate.
I hesitate to say what I took away from it, except that they didn't necessarily say it was all social investment as defined by Booth and Kersner, i.e. building schools and health centers. But I thought they said those monies spent on what Booth and Kersner called consumption should not be treated the way they were.
That's correct. Yep. So there were criticisms of the Booth-Kersner approach. Absolutely, Canada concedes that. There were criticisms of their approach, which is, one of the reasons why in its stage 3 closing, Canada didn't say, we're just going with Booth and Kersner. Canada did know, look, Booth and Kersner compared with the BTA makes the bond rate a reasonable rate. So Canada didn't jettison Booth and Kersner, but Canada did back away from it as the only way to look at things. Canada did acknowledge that, and my friends have told us many times that Booth and Kersner didn't survive on the stand. Only Hutchings did. And this, I get back to the point that, a professional expert witness testified better than Booth and Kersner. But it doesn't mean that Booth and Kersner's ideas are not worth a look, are not worth considering, is where I'm landing on this. So again, the overall approach is that I'm trying to say, you don't need to decide what is the correct approach. You need to decide whether Canada has taken an honorable approach, whether Canada's approach is rationally, is intelligible, transparent, justified, and rationally connected to the facts. And I'm telling you, you may not have made the same decision that Canada did, but Canada made the decision that it rejects the 60-40 approach, even if you accept Stiglitz and Hutchings, later adoption of this idea that, oh, well, that's conservative because if it had been social investment, it would have been higher. Canada's not persuaded by that. As I said, partly because, as I've taken you through the testimony, when they came up with the 60-40 approach, they had a vision of the Anishinaabe that Canada doesn't find compelling. And then when they convert their idea to say, oh, well, it's this, we pick up what Booth and Kersner said, some of it would have been social investment. And they don't actually go through an analysis. They just say, it all would have been, our rate, our 60-40 rate is conservative when compared to social investment. They don't actually say, yes, X amount or percentage would have been socially invested, that kind of thing. So, back to the point, economists can have different points of view. It's not dishonorable for Canada to prefer the point of view of Booth and Kersner and Smart and Bodway. And I had included that excerpt in the compendium about what Smart and Bodway said, because it makes some sense and it rings true. And I remind you that these are highly credentialed, internationally renowned Canadian public economists. And we shouldn't be throwing out the baby with the bathwater if there are certain parts of their testimony that didn't go over well. There were other points that Booth and Kersner and others made about why the 60-40 portfolio approach isn't the correct approach, but I think I've made my point here. And the main point being, I'm not trying to convince you, Justice Hennessy, about what the right approach is. I'm trying to convince you that there are different ways of looking at this, and the way that Canada looked at it is reasonable. It's supported on the facts and law. It may not be the decision that you would make, but it was a reasonable decision for Canada to make, and an honorable one. Now, I should address, Mr. Bass had noted that Canada failed to articulate this criticism of Stiglitz and Hutchings. He made the point that the First Nations repeatedly said, what about social investments? Okay, you don't like 60-40 because of the...
This is in the engagement process.
No, I'm talking about in submissions. My friend who made submissions on behalf of the contingent interest First Nations,
Yes.
he said,
it didn't make...
Canada never responded to our argument.
In the engagement process.
That's correct. Yeah. And I do I did want to point out, Canada does address it in the December 20th letter and in the January 27th letter. Not as clearly as Canada could have. We don't articulate the point very well, but we certainly do address the point in the context of Booth and Kersner having made the point that there are social investments would be made as well, and we need to consider that they depreciate. So it's not that Canada didn't turn its mind at all to this concept that there would have been social investments. Now, I want to take a look at the January 27th letter. It's in volume 1, tab 1, page 28, which is 40 of the record. Which, for the point that Canada explained that its decision not to use the 60-40 approach was also influenced by polycentric considerations. Namely, that the Crown must consider not only the honor of the Crown, but the wider public interest. And for that, I want to look at, my colleagues brought it up on the board, page 28 of the January 27th letter, record page 40. The paragraph that begins, some of the annuity augmentations that should have been paid would likely have been distributed to individuals and used for spending and investments in infrastructure, business, and human capital. Depreciation occurs in infrastructure, business investments, and human capital. So this is where I'm saying Canada did, maybe not well, but, or directly, Canada did at least avert to the relevance of spending on human capital. But Canada goes on to say, using the 60-40 investment portfolio approach would be inconsistent with the Supreme Court's finding that the Crown's duty to the First Nations is not a fiduciary duty. The Crown is not required to use the rate of return which would be most favorable to the First Nations. The Supreme Court explained that the Crown must consider not only the honor of the Crown, but also the wider public interest. Justice Hennessy, this is an example where what Canada is saying here is there are polycentric considerations. And, frankly, we've seen the effect that a very marginal difference in the bring forward rate has in the magnitudes of tens of billions of dollars when you bring things forward from 1850. So Canada knows this and has in mind that if we're going to pick the 60-40 rate, we're not going to be able to be considering the wider public interest.
I'm not sure what wider public interest means in any of the individual big drivers, but you mean the impact on the global number would have been something Canada says has an impact.
Yes.
And you're going to take me to, I hope, what that impact was or how you define that impact.
Well, that impact is, if you look at, for example, Mr. Hutchings' chart at tab 55C, the impact is tens of billions of dollars. And, Canada has explained in its January 27th letter why it believed that $3.6 billion is an honorable amount, not 30-some billion dollars, and has in mind polycentric considerations, including the wider public interest.
How do you define those considerations other than an amount of money?
They're described in the January 27th letter.
I can come to a conclusion based on running a household budget that the more money I spend on a car, the less money I have for vacation. But
yeah,
that's I'm looking for something from the Crown, presumably, that identifies what those thoughts are, what is in the consideration of the Crown when they say that an amount of money will have an impact on their obligations.
And I would go so far as to say, Justice Hennessy, and I thought I should should pull up to see how it's articulated in Canada's January 27th letter. The wider needs isn't just a question of, if we spend $36 billion on compensation for the RST First Nations, how do we then afford the needs of everybody else? I mean, the money is part of it, but it's more than that. I'm going to suggest it gets into issues like parity. There are problems if and I'm not just saying parity with the RST First Nations, but I'm getting at these concepts that are not just monetary, but really go to the root of reconciliation. Canada has in mind what is going to be a reconciliatory amount. And reconciliation has to take into account a lot of different factors. And one of those is, and it's expressed in Canada's letter here, the wider needs of the public. And Canada makes the point at page 42 of the record. This is its January 27th letter, when it's talking about factor 4, the wider needs. Canada says that much concerted effort remains necessary to enable all Indigenous citizens of Canada to improve their lives. Canada has determined its compensation to the Superior First Nations in light of the undisputed fact that there are hundreds of other impoverished First Nations communities across the country that rely on discretionary funding from Canada to assist in meeting their needs, settling Indigenous claims, and investing in Indigenous priorities. And goes on to talk about financial concerns, the fall economic statement and the tariff threat. So this is intended to demonstrate the kinds of wider needs that Canada has in consideration.
Can you give me that reference, please? Page number?
Page 30 of the January 27th letter, it's 42 of the record.
Thank you.
So we have about 5 minutes left. The next topic I wanted to address was share. And then I'm almost done that section, which means I'm pretty well right on time. But share, I might be more than 5 minutes. So do you want to stop here, or? I do think that even if I don't get to share now, I'll be able to finish before the lunch break tomorrow.
Which was your original estimate?
I think it was a day and a half for Canada and roughly a day and a half for Ontario. But I'm happy to
We'll break
reconvene
then.
tomorrow.
Sure. Break then and let you start with that, the share tomorrow. Oh,
Thank you.
Mr. Schachter's up.
Yes, I wonder if after we break for the day, we could just have the, Justice, if you could just stay for a moment to deal with possible scheduling.
Very good. Let's do that. Thank you. We'll break then. And I'll, we're finished court. Off the record.
This court is adjourned until tomorrow at 10 a.m.